Welcome to a courtroom showdown where confusion meets consequence. Today's case? A man out on bond for fleeing police, now caught in a tangle over a malfunctioning ignition interlock device, and a possible alcohol violation. But here's the twist. There was no DWI charge. So why the breathalyzer? Why the lockout? And who really dropped the ball? The defendant, the officer, or the system itself? Judge Fleischer isn't holding back, and neither should you. Stick around, because what starts as a simple hearing erupts into a tense debate over responsibility, procedure, and public safety. This one's messy, intense, and absolutely unforgettable.
I send you to go to test, and now you're testing positive for alcohol. Guess what happens now? He goes with you.
Not sure why he has this device on his phone.
I don't know, but there's a bond condition, and when you don't live up to the bond condition, there are consequences, just like anything in life.
Judge Fleischer lays it down early. Bond conditions aren't optional. They're court-ordered obligations. And when you break those rules, even if it's because of a faulty device, there are serious consequences. This is where the legal system reveals its strict backbone. It doesn't care if your equipment glitched, you're expected to comply or communicate. But here's the human side. Should a potential tech failure really land someone back in custody? Is it justice, or just rigidity? What do you think? Is the judge being too harsh, or just holding the line? Drop your thoughts below.
When you have a criminal case, you have conditions that you have to live by, and when you don't, there are very serious consequences. Mr. Steyer, you're on bond for fleeing a police officer. The report is that your device is in lockout, and it's been in lockout since 10/24.
Can we address the need for this bond condition?
I don't remember the case, so let's do PC real quick,
Yes, Judge.
and then we'll go from there.
So on August 17, 2024, at approximately 2 a.m., the officers observed a vehicle with a defective tail lamp and tried to initiate a traffic stop. The vehicle had ample opportunities to stop at multiple well-lit parking lots, but drove 0.46 miles of the final stop location. The defendant had red glossy eyes and continuously, I apologize. The defendant had red glossy eyes and the vehicle was running, and the officers also observed a slight odor of an alcoholic beverage from the defendant's body. The defendant had slurred speech and repeated, "I'm just trying to go home, I came from work," but the defendant could not specify his place of work. The defendant denied drinking alcohol, and the officers found an open container of color XO brandy container under the driver's seat.
Now here's where things escalate. An open container of brandy under the seat, and a Taurus pistol without a holster? That's not just bad optics, it's a legal minefield. Even if no DWI charges were filed, these findings raise serious safety concerns. But what complicates it further is the absence of field sobriety tests and no formal DWI charge. It's like everyone sees the red flags, but no one pulled the legal trigger. The question is, was this an officer's oversight or an intentional decision? And how much should the defendant pay for the system's indecision?
Taurus pistol under the passenger seat without a holster.
So what bond conditions were on there that they're alleging him to have violated? Let's see. You want to help me out?
Sorry?
This is Steyer,
Yes.
please.
I have him here. He doesn't have any previous violations. It's just that the device is in lockout.
What device?
The ignition interlock device.
So they put an ignition interlock. I guess the magistrate put an ignition interlock on it.
Charged with DWI.
Yes, conditions were ordered on August 28th. And
I get it, but he's alleged of alcohol in the car. I don't know. Begs the question, why didn't they charge him?
It should have been a DWCW judge. We're talking to the officers. It should have been a different charge.
I can't say this should have been a different charge. Officers are officers. We're supposed to allow them to do their job, and when their job doesn't rise to what folk think it should be, then all of a sudden they didn't do their job right. We want to talk to the supervisor. Officer didn't charge him, he didn't charge him. So he only got charged with fleeing. I don't understand why he's got this device on
Did
his
they
car.
do field sobriety tests?
They did not, Your Honor.
There was no DWI investigation done at the scene.
Was there any indication that he was intoxicated?
Yes, he had slurred speech, red glossy eyes.
And an odor of alcoholic beverage.
Yes.
Maybe the officer didn't think it rose to the event. At any rate, the officer didn't call it in as a DWI. And whether the state thinks it's shoddy work or not, we don't punish the defendant because the officer did.
Judge Fleischer hits a nerve here. It's not about sloppy police work, It's about whether the defendant followed the conditions of his release. Even if the arresting officer was inexperienced or failed to document everything, the burden of compliance still falls on the defendant. But here's a real debate. Should flawed investigations trigger flawed consequences? What's fair when both sides, the state and the individual, might have dropped the ball? Think about it. If an officer's mistake causes you to be bound by unnecessary restrictions, should you still be punished for breaking them?
Shoddy work.
Punish them for having bond conditions and not.
I fully understand that, and that's why I wanted to address the need for the bond condition as well as the bond. I understand that the machine's not working or it's in lockout status, but I'd also like to address why we're having it. So you didn't put it on there.
I didn't, but I think that it's a reasonable restriction when it is, for all intents and purposes. They just didn't charge it because maybe they had an officer that was a rookie, didn't know what they were doing. I can't tell you how many reports that I have see here that might as well have been written in Mandarin, you know?
From the defense perspective, this is
I understand
that
that.
we have to work with, and if they've got a rookie or if they've got a shoddy investigation, that shouldn't be his fault. Then that's their
But
issue.
it is his fault for not complying
Absolutely.
with the bond condition. That's what happens now, Mr. Steyer.
Just don't say
What can you possibly say that can help?
I don't, I was saying, I don't understand why it's locked. I called the people about it. I told them never like, it's a troubleshoot with your device. We'll try to figure it out on our end. But they never give no information about what to do.
This is where Judge Fleischer takes command. No delays, no excuses. He wants answers now. And frankly, who can blame him? A device in lockout, unclear reasons, and a defendant who doesn't seem to have the full picture. It's a recipe for courtroom chaos. But let's flip it. What if the defendant really did everything right? What if this was entirely technical failure? Would the judge still be this firm? Let us know in the comments. Do you think the judge is trying to protect the public or overstepping due process?
He can remedy that today, Judge.
No. Figure out now. I'm not going to let him go and then try to figure it after the fact. I'd like to do it now. What do you think? Do you know why it's in lockout?
I don't, that's what I'm looking at right now. So, because for all of our other devices we have, I don't see anything on the 24th or past that until the email sent to the DHR.
Would you mind looking into, please, as to why it's in lockout? It might take a little bit.
I
And
understand.
have you take a seat in the jury box while we figure this out, and then maybe 5-10 minutes, we'll come back and we'll
I
see.
understand.
And then,
From the defense perspective, we should still address the need of this. I mean, the officer is part of the state. He is part of the state's witnesses. They didn't make the allegation. They didn't file the charges. I'm still contesting outside of the fact that the machine doesn't work. And mind you, he didn't make the machine. He doesn't calibrate the machine. The machine doesn't.
The defense argues that Mr. Steyer shouldn't be penalized for a machine he neither built nor calibrated. Fair point. But Judge Fleischer returns to the ultimate accountability principle. If you're on bond, you're responsible for ensuring your monitoring tools work. No excuses. No shifting blame. And when you're already skating on thin ice, like Steyer with a fleeing charge and signs of alcohol, there's zero room for error. This is more than technical difficulty. It's a test of personal responsibility. And unfortunately for Steyer, it looks like he just failed.
Work that could be no fault of his own, and we can correct that today. But if
let's do, Mr. Slider.
yes,
I was going to send you now for a drug and alcohol test. Let's see what pops up. No,
that's
we
fair,
can
Judge.
see how he's behaving while he's on bond.
My judge just comes back with nothing on it. It will let me.
Yes. This question is if this drug test is clear, free of any alcohol, any drugs.
Let's cross that bridge when we get there.
We'll do,
We
Judge.
need for a test now, and we'll go from there. If you're clean, it'll go a long way for you. If you're dirty, cross that bridge when we get there.
Yes, sir.
My only concern, Mr. Steyer, is public safety. Nothing else matters in my life. And if you're going to play adult games, or if you play stupid games, you win stupid prizes or you get adult consequences, right? When you act like a child, we treat you like a child. If you do great things, then we congratulate you and reward you, right?
Sir.
Okay, just take a seat for a moment, Chair. We'll be
Thanks,
back. All right, Mr. Slider. So I'm not happy with it.
I know.
It's unacceptable. He's in lockout. A court order is a court order. You know, he's in lockout because he failed to go get it calibrated. Not because of this, not because of that, because he didn't call, no. You failed to go get it locked down, or you failed to go get it calibrated. That's why it's in lockout. I send you to go to test, and now you're testing positive for alcohol. Guess what happens now? That's right. Actions have consequences, Mr. Steyer. He goes with you. I'm sorry, but I can't continue to do it, man. It's unacceptable.
Judge, are you revoking his bond? What are you gonna set the new bonds at?
5,001.
5,000 more than the original bond,
Oh,
which is 5,000?
what's it at now? Is it 100?
Let me check.
It's at 100, so 5,001.
So bond, okay.
5,001, yes. Goes with you. Right.
So what happened here? Mr. Steyer's device was in lockout. He claimed confusion, but the judge saw in action. And once a court-ordered test confirmed alcohol, the bond was revoked and a new one set at $5,001, up from just $100. The message from Judge Fleischer was loud and clear. Actions have consequences. This case is a sharp reminder that in the legal system, compliance isn't just a formality, it's survival. Backhand index pointing right. If you found this case as shocking as we did, hit that like button, drop a comment with your thoughts, and subscribe for more jaw-dropping courtroom breakdowns just like this.